Good afternoon and welcome to this webinar, Is Your Estate in Order? My name's Doug Miller and I'm an attorney and gift planner here at Ozark Christian College. I have over 30 years of experience in estate and gift planning. I want this webinar to be as practical and useful as possible. So I've come up with an estate planning checklist, and as we go through it, you can evaluate yourself and say, yes, I've got that taken care of, or no, I haven't. I just want this to be useful. And if you didn't receive a copy of the handout, it should be in the chat function of the Zoom call. And if you aren't able to access that, let me know. My contact information will be up at the end of the webinar, and I'll be glad to send it to you. Well, first of all, I want to start off very practically with the question answer format here. The first question I have is, have I prayerfully considered what God would have me to do with the property he's entrusted? I want us to look at 5 different scriptures about estate planning. The first one is from Psalm 24:1. The earth is the Lord's and everything, the world and all who live in it. The first principle is God owns everything. As the creator, he's also the owner of everything. We're merely in possession of his property, and we're responsible for how we use his property. What do we have that's not a gift from God? The second principle is we must provide for our dependents. The scripture, 1 Timothy 5:8, if anyone does not provide for his relatives, and especially his immediate family, he's denied the faith and is worse than an unbeliever. So there are people that are dependent on us, our spouse, our minor children. I'd also argue that your church and ministries you support are dependent on you. Have you provided for them? Next, our primary motivation should be love. From 1 Corinthians chapter 13. If I give all I possess to the poor, surrender my body to the flames, but have not love, I gain nothing. Obviously, God is motivated by love, and we should be motivated by his love. That should be our primary motivation. Next principle, people are more important than possessions. In Luke chapter 15, Jesus tells us 3 parables. The first is the parable of the lost sheep, where a shepherd was watching 100 sheep and one wandered off. The shepherd left the 99 to go find the one sheep and returned back rejoicing once he found him. Jesus said, there'll be more rejoicing in heaven for one sinner who repents than the 99 who didn't need to repent. Next, he tells the parable of the lost coin, where a woman had 10 coins but misplaced one. She turned her house upside down and looked until she found it. And when she did, she told her neighbors and rejoiced. And finally, the parable of the lost son, or the prodigal son, in which the younger son receives his inheritance, goes off and squanders it. But the father waits for his return and runs out to meet him as soon as he sees him. Now, these 3 parables aren't just about sheep, coins, and even parenting. Rather, they reveal God's heart for the lost. So people, and lost people in particular, are more important than our stuff. We shouldn't forget that as we make plans. And finally, as stewards of God's property, we're accountable to the owner. In Matthew chapter 25, Jesus tells the parable of the talents, very familiar. 3 stewards were given control over some of the master's property when he left. And when he returned, he found the first 2 had taken what was given and caused an increase for the master. He said, well done, good and faithful servant. You've been faithful with a few things. I'll put you in charge of many things. Come and share in your master's happiness. We also remember the 3rd steward who hid the talents and didn't put it to work, and the master was very harsh with him. So the principle here is we are going to be accountable to the owner, to God, for what we've done with his property. We hear a lot about tithing while we're alive, right? Every week we hear an offering meditation that we should tithe. But how often do you hear someone talk about tithing when you die? Do you think God stops caring about his property when we die? I don't think so. I think we need to have, again, a biblical perspective, a scriptural basis when we make any important decision, especially what to do with the property he's entrusted to us. Next question. Have I signed a document to authorize another person to manage my assets and property if I become incapacitated? When I say incapacitated, I'm talking about unable to care for myself, whether that be physically, mentally, or both. As we're living longer, there's a greater possibility that there'll be at least a short period of time that we aren't able to take care of ourselves and we'll need help. I've seen statistics that say up to half of the 75-year-olds and 2/3 of the 85-year-olds need some type of assistance. We may need help managing our money and paying our bills. If you developed a dementia, Alzheimer's, senility, or have a stroke, you may not be able to take care of yourself. So what happens if a person has not made any plans and has that type of a disability where they're not able to care for themselves? Well, it may be required that their family member or friend has to go to court and petition to be appointed their guardian or conservator. I use the phrase here, conservator, which means over the person's finances. So if you are unable to care for yourself and you haven't appointed somebody, then it may require a trip to court to have a conservator appointed. The conservator would then, what essentially happens is they take the individual's ability to take care of that property away and vest it in another person called a conservator. Well, there is a way to avoid that situation. What you can do is, while you're still able, to appoint someone to care for you and your property if you ever become unable. That document's called the durable power of attorney. Durable means that even if I lose capacity, I want my agent, the person that I've appointed, to serve. The phrase power of attorney confuses a lot of people. They think it has to do with an attorney or a lawyer. It just means someone representing you. So a power of attorney means someone's acting on your behalf or to take care of your property and to take care of you. In a durable power of attorney, while you're able, you appoint someone to take care of you if you ever become unable. It's important to note, the power of attorney is only in effect while you're alive. The power of attorney dies when you die. The power of attorney, the person that you've appointed as agent, only has authority to act for you while you're alive, but no longer after you're dead. I want to point out, you could download a power of attorney form from the internet or find one in the library and make a copy of it. I want to caution you about that. Realize that when you give someone power of attorney, it is a very awesome power. They can sign your name on deeds, car titles, bank accounts, checks, finances, your investments. Not something you want to do haphazardly or without considering the effect of giving someone that much authority. It's worth having an attorney or someone help you so that your wishes are carried out appropriately. When you give someone the ability to sign for you, they can do most anything. In the power of attorney, you can specify when it takes effect, now, or in the future when I can no longer do it myself, and how much authority they will have. Let's go on. Number 3, have I signed a document to authorize another person to make medical decisions for me if I become incapacitated? We've just talked about appointing a financial power of attorney to make business decisions for you if you're unable. Now I want to talk about appointing someone to make medical and healthcare decisions. If an unconscious person is brought into the hospital, they're going to stabilize him or her. But once they're stable, the hospitals and doctors may not do any further treatment because they need the consent of the person before they will provide care. They're afraid of being sued if they operate without consent. So sometimes the hospital files a petition for guardianship over that person who can authorize the needed medical procedures. And when you hear guardian, you usually think of children that don't have parents and they need to have a guardian appointed. But the probate court also appoints guardians for adults who cannot take care of themselves. As I mentioned, guardian is a person and conservator is over their property or their finances. You can avoid having a court-appointed guardian by signing medical or a healthcare power of attorney. Just like the durable power of attorney for finances, this power does not take effect until two doctors say you can no longer care for yourself. Obviously, if you're still capable, you'll be making your own medical decisions. As you might imagine, there's times when it's hard to tell if a person has the ability to make decisions for themselves. It's not clear. That's why we require the professional opinion of two doctors to make that determination. Your agent would not have any authority to act until two doctors certified that you are unable. Again, that's a springing power of attorney at a future point, not an immediate power of attorney you give right now. Number 4, have I signed a document to communicate my preferences for end-of-life decisions? At what point would you like to be kept alive artificially, and when would you allow nature to take its course? Perhaps you've heard the cases of Nancy Cruzan or Terry Schiavo, where there were family disputes about end-of-life decisions. Very tragic situations. However, there may be one good thing that came out of those tragic cases. People now realize the importance of making their wishes known in advance about their end-of-life decisions. In an ideal situation, you'd make your own medical decisions. I want everything, I don't want anything, withhold treatment if there's no hope of recovery. But again, while you're able, you can direct what treatment you would allow to be withdrawn. Most states have forms that you can use to make these kind of healthcare decisions. If you're admitted to the hospital, they may ask you if you want to complete one so that they can know your wishes. It also mentions on this slide a living will. A living will simply says, if death is imminent, you can withdraw treatment. In other words, it really doesn't take effect until the day before you die. At that point, you've said it's okay to disconnect and let me pass. I believe it's much more helpful to appoint a person that you trust to make decisions like that instead of waiting until death is imminent. A healthcare power of attorney takes effect as soon as you can no longer make or communicate healthcare decisions. That may be a long time from when death is imminent. A do not resuscitate document. This is a very special type of document that says, I do not want any cardiopulmonary resuscitation. We're familiar with CPR, with someone providing CPR to another that needs it. We're also talking about any kind of cardio treatment or pulmonary treatment, such as a ventilator or intubation. Again, different states have different laws. In Missouri, we require that you and your doctor sign a do not resuscitate document. Again, I prefer appointing a healthcare power of attorney and giving them some instructions and directions on what kind of treatment you would like to have. You need to appoint the person that you appoint. You need to talk to them and tell them what your wishes are, what you would like to have or not to have. When the doctor comes out of operating room and goes into the waiting room and there's a dozen people there on your behalf, who will he or she talk to? The person that holds the medical power of attorney, the person that you designated to make those kind of decisions in advance. Number 5, have I signed a document to communicate my preferences for organ and tissue donation? Obviously, organ and tissue donation can be made on an organ donor card or in some states on the back of your driver's license. You also, it's important that you talk to your family about what you would like to have because they'll be asked to make the decision. And if you've not talked about it, they may not know what you would prefer. So have the discussion, yes, I would agree to that, or no, I would prefer not. As I mentioned, a power of attorney dies when you die. However, in Missouri, there's a small exception under the healthcare power of attorney that says that the person that you appoint to make those medical decisions can also, you can give them the authority to consent to organ and tissue donation. So again, let them know what you prefer. Number 6, have I communicated my preferences for funeral or memorial service? Do you have a preference? Do you want to be embalmed or do you mind to be cremated? cremations are becoming more popular as the costs of traditional funerals increase. I'm not advocating that you go to the funeral home and pre-plan your funeral, but some people do. It is one less decision for the family to make. You can describe where you want the services to be held, who you would want to officiate, preach, sing, be pallbearers. All that can be pre-planned at the funeral home. But you don't have to go to the mortuary to pre-plan your funeral. You can have a discussion with your family and your loved ones, or it can even be a letter of instructions, who you would want to have contacted. Again, the type of service that you would like to have. If you're a veteran, would you want military honors? Would you be interested in donating your body to science? Obviously, if you set out your plans, it's much easier on the family because it'll be one less thing for them to decide, and they can be confident they're carrying out your wishes. Number 7, have I signed a document to nominate guardians for my minor children? When we had minor children, my wife and I selected guardians for them. We wanted to avoid a fight between my family and her family, either to get the kids or not to get the kids. Obviously, a family feud is not the way you want to start the relationship after you're gone. Who should you appoint as your guardian? Well, clearly the person needs to be able, physically and mentally, and in their situation, able to do so and willing. If you appoint someone who's not willing, then you've just wasted your appointment. What about grandparents? Well, if grandparents are living in a retirement community, maybe it's not the best place for children. Maybe it'd be a better fit for one of their aunts or uncles. Sometimes it's not a relative. I want them to be raised by someone who shares my values. Maybe it'd be a friend at church that has children our age, and their kids go to church and go to school together. It would be a lot less disruptive for the child to go with the trusted family friend or family member that lives nearby, as opposed to sending them to live with family out of state. And of course, I always recommend appointing alternates and backups if the person you appoint can't serve for whatever reason. I also want to note that you can't totally avoid probate if you have minor children. A probate judge must appoint a guardian by court order. That's not necessarily bad, because the probate court will make sure the guardian is willing and able to serve as a good fit for the child. The court will also make sure the money gets held for the children. So court supervision can be a good thing. The court will require annual reports and make sure that the children are being taken care of and that whatever's left is given to the children. Which brings me to my next question, number 8. Have I signed a document to direct the distribution of my estate to my minor children at my death? If you don't make any plans, the probate court will give your money to your children as soon as they become adults. At what age do children become adults in most states? Age 18. In other words, on their 18th birthday, all of their inheritance will be given to them. Now, you might be more responsible than me, but I shudder to think what I would have done with thousands of dollars on my 18th birthday. I think it's fair to say I would have bought a sports car and had a lot of fun, but had very little to show for it a year later. So many parents want their children's inheritance to be held until the children get to be 21 years or older. They want their children to be a little more mature before giving them money. After going to college or working a few years, they probably will have a better idea about the value of money. So in the meantime, you appoint a trusted person to hold the money for the children until they reach the age that you've set. Now, it can be the same person that you've nominated as guardian, but it doesn't have to be. My wife and I decided to appoint the same person. We trust them with our kids. We trust them with our money. Whomever you designate to hold the kids' money can spend it on the children before they reach the age you set. For example, they could buy braces for their teeth. They could pay the child's college tuition or buy them a good used car. But it's the adult, not the 18-year-old, making those kinds of decisions. Number 9, Have I directed the ownership of my assets and property at my death? This is what you thought I was going to talk about when you heard estate planning. What happens to my stuff when I die? Well, I want to talk about three quick options. The first is if you've not made any plans, then your property will be divided according to the intestate succession plans in your state. That's a legal way of saying if you die without a will, don't worry, your state legislature has drawn one for you. Is that reassuring to you? Well, the lawmakers in your state guesstimate that you would want it to go to your family members equally. Not necessarily a bad plan. Maybe it's the way you wanted, but maybe not. So let's look at the next one, a last will and testament. We all know a will is a written document that distributes your property at death. In a will, you can nominate guardians for your minor children. You can nominate the executor, who we now call a personal representative, and you can make a plan for distributing your property. The last bullet point on this slide is titling assets. So if you've been waiting for me to say something important, here it is. What happens to your property when you die depends on how it's titled. What happens to your property when you die depends on how it's titled. Property that's in your name only when you die must go through probate. Property that's in your name only when you die must go through probate. Why? Because you're not there anymore to sign the deed, to sign the car title, to sign the check, etc. Your heirs will need a court order to get the property out of your name. Next, wills don't avoid probate. Wills tell probate what to do. So again, property that's in your name only will have to go through probate. If you have a will, they will distribute it according to the will. If you don't have a will, they'll distribute it according to intestate succession. And finally, the way to avoid probate is to change the title of your property while you can. So let's look at the next slide. Do I know how my property is titled? And again, when I say property, I'm not talking just only about real estate, but vehicles, bank accounts, investments, other stuff as well. Do I know how it's titled? So first of all, it could be in sole ownership, in this example, in Tom's name only. It also could be held as tenants in common, Tom and Jerry. This is called tenants in common. Tenants in common is kind of like a business partners. Tom owns 50%, Jerry owns 50%. If Tom died, his half would go to his family and not to his partner, Jerry. There's another type of joint ownership, and that's with rights of survivorship. So in this arrangement, it would be titled Tom and Jerry with rights of survivorship, meaning whomever outlived the other receives it all. So if Tom died, it all goes to Jerry. Now, that typically is the arrangement is for husbands and wives, for married couples that own property in both names. When one dies, the surviving spouse owns it all. However, you could also have joint ownership with rights of survivorship with a parent and a child, or you and a friend, so that it goes to the survivor. You should not presume that it goes to the survivor. In Missouri, if it's any two people besides a husband and wife, it would be assumed that it would not be survivorship. So you need to specify that if you want that. Fourth bullet point talks about transfer on death, a way of titling property. It's a relatively new way of titling property available in many, but not all states. Here's how it works. I take property that's in my name only, and I say, I want to retitle this vehicle from Doug Miller to Doug Miller, transfer on death to A, B, and C. While I'm alive, I'm 100% the owner, and A, B, and C have zero interest. So if I want to sell it, give it away, mortgage it, I don't need their permission. I don't need their signature. In fact, they don't even need to know about it at all. But when I die, it automatically transfers to them. All they have to do is show my death certificate, and they're going to say it's yours. You can put this on most all kinds of property, real estate, vehicles, bank accounts, stock, investments, just about everything, again, depending on the state. Here in Missouri, it's called the Missouri Non-Probate Transfer Law. It allows us to accomplish what most people want all along, which is I want my property to transfer, but not until I die, and I don't want it to go through probate. So you can talk to the bank about putting TOD on your accounts, or you can talk to your financial advisor about putting transfer on death on your investments. You can talk to the Department of Motor Vehicles about putting transfer on death on your vehicle titles. You might need an attorney to prepare the special deed for transfer on death for real estate. It's a good option to know about. There's only one string attached, and that is it's subject to payment of bills or creditors. So if you transfer on death everything to your children, but they don't pay creditors, then the creditors can open a probate and get paid. Finally, I listed the trust. So in this case, we've got the Tom Trust dated today. The full name is Irrevocable Living Trust. It's revocable, meaning they can change it or revoke it if they want. It's living because I created it while I was alive. Here's how a trust avoids probate. Remember, property that's in my name only, when I die, has to go through probate. So I establish a trust as a way of owning the property. I make myself the trustee or manager of the property in the trust as long as I'm able. But when I am no longer able to serve due to incapacity or death, then I've appointed a successor trustee to take over for me. If I become incapacitated, I want my successor trustee to manage the property for me and take care of me. When I die, I've told the successor trustee, distribute my property to these beneficiaries. So again, I don't own it. It's no longer in my name legally. It's owned by the trust, but I made myself trustee, so I continue to use the property as always. I can put property in the trust, take property out of the trust. Once I've set it up, I can do it whatever I want. But then again, the way it avoids probate is I've changed the titles of my property to the trust name, and it's no longer in my name only. So let's look at these and see how they go for probate. Let's look at how this works for probate in each type of this asset. So again, property that's in Tom's name only has to go through probate. Property that's in your name only when you die goes through probate. Tenants in common, when Tom dies, his half has to go through probate. It was not titled with survivorship. Third, joint tenants with right of survivorship property would not go through probate. It would all go to Jerry. Transfer on death would not go through probate. Because of the law, it would go from Tom's name to Jerry's name. All he would have to do is show a death certificate. Again, in the trust, if Tom said, I want my beneficiary to be Jerry, it would go to Jerry without going through probate because it's not in Tom's name only anymore. Okay. Number 11, have I coordinated the titles and beneficiary designations to be consistent with my other estate planning documents? So let's stop and imagine you've written a will and you want, in the will, it says, distribute everything to my 5 children equally. Well, imagine you have a bank account and you've named your oldest child as co-owner with survivorship, or you've said, I want this in my name, transfer on death to my oldest child. So when you die, who gets that bank account? Does it go under the will to the 5 kids? No, it was not in your name only, so it doesn't go under the will. It'll go directly to that oldest child. So the way you title your property determines what happens to it when you die. Property will not be distributed under your will unless it's in your name only and goes through probate. In a similar way, your trust will not be distributed according to your trust unless it's titled in the trust name. So how your property is titled determines what happens to it when you die. So imagine you have life insurance and you list, again, your oldest child as the sole beneficiary. Your will says divide it 5 ways. Who gets the life insurance? The life insurance company said you signed the contract saying to pay this one child, and that's what we're going to do. If you want it to go to all 5 children, you should put all 5 children as the beneficiaries. Same answer for retirement accounts. Individual retirement accounts, 401ks, they have beneficiary designations as well. It's going to go to who's on the title. So my point about coordinating this is if you want it to go to 5 children equally, you should put that on the beneficiary designations for jointly titled property, transfer on death property, life insurance, and retirement accounts. Okay. I say if you list it, if you leave it to one child, it's kind of the hope plan. You hope they'll share it with their other siblings. But if you list all 5, they have to. Number 12, do I know the tax basis and market value and amount owed on my assets and property? So I want to talk about taxes very briefly. If you have an accountant, you should ask them about your tax situation. Let's imagine you've purchased some stock for $1,000, but today it's worth $10,000. If you sold it for $10,000, the IRS would consider that $9,000 profit as taxable capital gain. One way to avoid capital gains on appreciated property that's increased in value, is to donate it to a charity like your church or the college. If you donate that appreciated property to the charity or ministry, the ministry can sell it and receive the entire $10,000 tax-free. You'll receive a $10,000 tax deduction. Everybody wins except for the IRS. Why does the charity get to sell it tax-free? Because the tax rate for charities and ministries and churches is 0. So if you have corporate stock that's gained in value or real estate that's appreciated in value, and you want to make a charitable gift, you can totally eliminate that tax on that asset. It's an ideal gift for a charity or a ministry. Our U.S. tax code is written to encourage people to make charitable gifts, including to churches and ministries. The charity will receive the full $10,000 and you'll get the $10,000 tax deduction. I also want to talk about traditional IRAs and 401ks. As you know, there's traditional IRAs and Roth IRAs. Roth IRAs, you put in after-tax money that's already been taxed. It grows and you withdraw it tax-free. But a traditional IRA on 401k, you take a part of each year, you put a contribution in that account and it grows tax-free. So you put in pre-tax money that grows, and when do they get taxed? When you withdraw the money. The IRS requires you to take money out when you turn now 72 years of age. Why? Because they're worried about you? No, because they want their share of the taxes. They've been patient, but there's a limit. If there's money in your IRA when you die, your children or other beneficiaries will have to pay taxes when they take money out of the IRA or 401k. However, if you leave part or all of your traditional IRA or 401k to a charity or ministry, there'll be 0 taxes deducted. As a result, my wife and I decided to give a portion of our retirement accounts to Ozark Christian College. Traditional IRAs and 401ks are great assets to give your church or ministry. Also, want to talk briefly about making a charitable gift while you're alive. The charitable IRA rollover, it's called, those that are 70 and a half, again, were required to take minimum distributions, but you can direct that required minimum distribution be directed to a charity, not come to you. Don't send it to me, send it to my church, send it to a ministry. That will count as your required minimum distribution. And you can do that for up to $100,000 per year directly to a ministry or charity. So let's say you want to make a tithe. You could make your tithe from your IRA instead of from a check out of your bank account. Remember, if I give that IRA to my children, they pay taxes when they remove funds. So be aware that if you're over 70 and a half, you can make a gift directly from your IRA to a charity that counts as your RMD. You don't get a tax deduction because it doesn't show up as income. Number 13, have I made plans, costs and taxes to administer my estate? We've already talked about income tax and capital gain taxes and how to avoid and minimize those. I also want to mention estate tax or inheritance tax. If your estate is worth less than $11.7 million, you'll own 0 federal estate tax. And in Missouri, you'll own 0 state tax. Now, other states may not follow the federal government's lead, and they may have they may start collecting tax at $1 million or $5 million. But again, any gift that you give to a charity will reduce that amount that is taxable at the federal or state tax level. We've also talked about making plans to avoid probate. Obviously, that eliminates the cost of hiring an attorney, paying court costs, and other probate expenses that could take up to 10% of your estate off the top. So I always ask, if we could save you 10% of your estate by coming up with a plan to avoid probate expenses, would you consider giving that amount to your church or a ministry like Ozark Christian College? To me, that's very wise stewardship. You've freed up money that otherwise would have gone to expenses and attorneys and executor fees, and you've turned it to the Lord's work. Number 14, am I confident that my current estate plan will accomplish all of my intentions with the least amount of cost, delay, taxes, and effort for my loved ones? You have a choice to make. If you do nothing, it'll be easier for you, but it'll be much more expensive and much more complicated for your heirs. They'll have to incur probate costs, attorney's fees, and taxes. Or you can take action now and make plans and reduce that amount of time and trouble involved. Making a plan to avoid probate and redirecting that money to your church or ministry is very good Christian stewardship, but you must act now. Will you make a plan to make it easier on your loved ones and the causes you care about? It's much easier to make plans while you're alive than after you're gone. If you wait till after you're gone to change the titles of your property, your heirs will have to go to probate court and ask a judge to do it. It's good to look at property and say, what happens if I die? Will this be in my name only? Will it have to go through probate? If not, is it titled in a way that it will avoid probate? So you must take action. You must do the work now and make it easier for your loved ones and for you to make plans for giving it to charities and ministries. And number 15, have I consulted with professionals to create my estate plan? Obviously, an attorney can help you draw up a will, a power of attorney, transfer on death title, and help you avoid probate. If you have an accountant, it's very wise to talk to your accountant. They know your situation. They know those assets that have taxes tied to them and would be ideal gifts for charity. So they want to help you minimize your tax and, again, increase your impact for ministries and charities. Your life insurance agent can help you with the beneficiaries on your policies. Again, you could name a life insurance beneficiary as a ministry or to your church and make a significant gift. Financial advisors can help you with your retirement accounts and your stocks that have appreciated in value. Again, there's a lot of money invested in retirement accounts. If it's a traditional retirement account, it's going to be taxed when you withdraw the money. Your financial advisor can help you identify those assets that would be ideal for making charitable gifts to your church or ministry like the college. Again, thankfully, our federal government still encourages donations to charities, including churches and ministries. Many times when you're facing a tax, you can reduce or eliminate the tax with a charitable gift. Not all of it has to go to charity, but every amount that you give to the charity will help lower your tax liability. Also want to mention the Ozark Legacy Society. Ozark has been training men and women for Christian service since 1942. Throughout the years, Ozark has received a lot of gifts from people through their wills and trusts and IRAs. If you plan to make a gift to the college, we would like to invite you to join a special group known as the Ozark Legacy Society. Just let us know you've named Ozark as a beneficiary in your will, trust, life insurance, or retirement account. We want to thank you. And as Legacy Society member, you're invited. I've put some of the member benefits here. Special events. We'll present you with a desk clock and a discount card for our bookstore, and recognition in the Ambassador magazine and on the college website for other Legacy Society members. This is optional. If you prefer to remain anonymous, we understand that. But we also know that your gift and your name will add credibility to the idea of leaving a gift to Ozark, leaving a gift for the future of the ministry. And finally, of course, you have the benefit of knowing that you're going to be helping people, helping future generations that will be trained for Christian service, go out and reach the world. So let's review. How did you do on the checklist? Did you mark yes on everything? Or are there a few items you need to take care of? If you have any questions or would like a free estate planning guide, please contact me. I want to be a resource. I have my contact information on the screen and my phone number. You also can find a lot of information about plan giving, estate planning, and making a gift from your will or trust at occ.edu/legacy. You also can find an online form to join our Ozark Legacy Society. I want to thank you for taking time to learn about estate planning and how you can be a good steward. Thank you.